Hi, I'm Rory Veal, and I'm here with TJ Angstman, an attorney from Boise who's been involved quite a bit in Tamarack throughout the years. He's been involved as one of the litigators in the continuing legal battles. He's kind enough to talk to us today about what's going on the legal front and where he sees Tamarack going in the future. Hi, Mr. Angstman.
Hi.
Thank you for meeting with us today to talk about this. Can I call you TJ?
Please do. Thanks, Rory.
Okay, great. Can you summarize at this point where you think the legal process is?
Well, first of all, I guess, it's important to know that I'm not presently representing anybody in the case, so I haven't been following everything completely, but I have been following as well as I can to know what's going on. So hopefully I've got the facts straight. I want to make, just to say that. But where things appear to be is that the court is just hearing final arguments on issues like attorney fees and issuance of final judgments so that a decree of foreclosure can be entered on different portions of the property so that which would trigger a sheriff's sale.
You mentioned different portions of the property. Why do you think the court is treating these different areas separately? Like there's the Whitewater area, the Trillium Valley, Lake Wing, the village, and then the rest of the property?
Well, I think that the court, of course, is going to be looking at what the parties are asking. So it may not be the court's desire to treat them separately, but the parties are asking to have different parts of the property treated separately. And the reason I think the parties are doing that, I can surmise, is because of whether or not there are junior lien creditors to Credit Suisse. And so it seems to me, if you look at the way the parcels have been divided up in these foreclosure orders, is you have the parcels where there are few or no junior lien creditors to Credit Suisse, and those parcels where there are disputes amongst people who obtained priority over Credit Suisse, such as the Trillium parcel, the Lake Wing, the village, and the Fairmont site.
There's a hearing coming up on the 9th. What can you tell me about the issues that you think are going to be reviewed or even hopefully settled at that hearing?
Well, the different parties have proposed decrees of foreclosure and final judgments for various parcels of the property. And the Trillium parcel, the village, and the what they call the initial Tamarack property, which would be the Heritage, the Ski Hill, and the other portions of the property that I didn't name already, the other pad sites and such. And so, what I think that the parties want is a final judgment on those parcels of property that don't have junior lien claims or don't have many, because at least Credit Suisse wants to be able to sell that freely without the risk of an appeal that would stop the sales process of those parcels.
You mentioned appeal. I think everyone's hoping that there's going to be a final judgment issued, then a decree and an order of sale. If the judge does, and I guess that's a big question, do you think the judge will actually issue any final decrees or final judgments? But if he does, what happens to those? Can they be appealed?
Well, it's certainly not a foregone conclusion that the judge will decide to enter a final judgment on some but not all of the case. And the reason I would say that is there's a preference in the courts against what I would call piecemeal appeals. And that is appealing part of a case but not all of it, because then the case can have repeated trips to the Supreme Court before things are all figured out. And so the general policy is against piecemeal appeals, and so I won't call it extraordinary. I've certainly been able to get what's called a 54B certificate on a partial judgment before. But the judge has to look at that and decide whether or not he is concerned that a party might file an appeal to that decision. Because once it's certified as final, then it's appealable. Right now, none of the decisions that have been made by Judge Owen over the course of almost 4 years, I guess 4 years in this case, none of those have been subject to an appeal. So now, once a decision is certified as final, that decision and all the decisions in that portion of the case would then be subject to an appeal. And the problem with that is that then The rules say that if a partial judgment is certified as final and then appealed, then it stays all the rest of the case.
When you say stay, what does that mean?
That means that Judge Owen will lose jurisdiction to decide and enter any other decisions in that case. Entering a final judgment potentially on the other aspects of the case might also be stayed.
And this would be appealed, so his final judgment can be appealed, and it would be appealed to the state Supreme Court.
Effectively, you file an appeal with the state Supreme Court, and then they decide whether the Court of Appeals will hear it or they will hear it. But yes.
There are a couple of other little issues that have been kind of surprising to come up. One is that Wells Fargo has entered the fray at this late date, claiming they have some standing in the case. And the other is a little bit puzzling in how the judge is treating the credit bidding process. Do you have any opinions on that?
Well, as far as the Wells Fargo, I'm just familiar with what it is. I don't know what their argument is, really, because my involvement in the case stopped, about a year ago, and their claims, that's about when they were starting to raise their head. But it has to do with the modulars in the design plaza, if I'm not mistaken. So, really, those should not be considered real property. And so, in my view, they should just be filing a claim and delivery action, picking them up and taking them. They're not they're personal property. They were never built on foundations. They're just temporary.
What do you know about the credit bidding situation?
Well, the credit bidding is another matter, and this is part of the, this whole, having the different sales, the different judgments and decrees of foreclosure. But the question really is whether or not one of the lien creditors can utilize the amount of money that the judge says they're owed and then make a bid to purchase the asset and not have to bring money in with them. So they call that a credit bid, meaning they get credit for how much they're owed when they make a bid to buy the village, for instance, where there's a lot of junior creditor or creditors senior to Credit Suisse.
My understanding, TJ, is that the judge is actually requiring the creditors to actually bring cash. Is that normal?
Well, what's not normal is a situation that we have here where there's multiple creditors with the same priority, and you can call that pari passu priority or whatever. They are of equal priority under the statute. Material providers get their priority based upon being a material provider, not based upon when they provided the materials. So it's a little bit of a misconception out there that the first person to work might have the best priority. It's not necessarily true. All material men have the same priority, and so because that's a little bit uncommon, where you have so many people on the same level of priority, it makes sense to make them bring in cash, to me, because what if how much if you make a credit bid and you're sharing your priority, then you really can't credit bid because the other person's at the same level as you. Now, I could see allowing someone at one level having a credit above, if they were the only person at that level, being able to make a credit bid. But where they're sharing priority, you could end up with a fiasco after the end of the sale. There still may be more problems. It may create more problems than you solve. So
everyone wants to know where things are kind of headed. We've talked a little bit about the judges issuing a final judgment may not be as big a slam dunk as everyone thinks. But let's assume, or let's postulate that he does issue a final judgment, and let's postulate that judgment is not appealed. What would the process be, or how would it play out, and when could we expect the very first sheriff's sale?
Well, I would assume let's just say that the final judgment is issued sometime here in the month of May. Typically, Judge Owen would take a matter under advisement and write a written opinion. And so, assume by the end of May he issues that opinion and grants a 54B certificate on the final judgment, making Credit Suisse's decree of foreclosure on what we were calling the initial foreclosure property, which is everything but the Village, Trillium, Lake Wing, and the Fairmont site. That has to be published in the newspaper, okay? And then they'll post it at the courthouse down here in Cascade. And after about 30 days, the sheriff could then go out and conduct an auction of that property at the courthouse steps in Cascade. And I've done judgment foreclosure sales up here in Valley County, so I'm fairly familiar with the process. That could happen as early as the middle of July. Really could quite easily occur that fast if there was no appeal. And even if there was an appeal, because you'd have to post a bond to stay the effect of the judgment, Credit Suisse could do the sheriff sale even in the face of an appeal. Mm-hmm. There's some risk in that, but because the person whoever might appeal hasn't posted a bond, the sale would go forward. So by the middle or end of July, I could see that occurring.
Can I backtrack for just
Sure.
1 second? The parties relative to the judgments for the Village and for Trillium, the primary creditors, or I guess the primary creditors, have asked for judgments to be issued. Credit Suisse seems to have filed objections to that. Is there any real advantage to Credit Suisse filing those objections? Why are they fighting it?
Well, I think that Credit Suisse really wants to get a final judgment. And I misspoke a moment ago. The final judgment, likely Credit Suisse wouldn't ask the sheriff to start the foreclosure sale for 42 days after that judgment had been entered. They could ask, I think maybe 2 weeks later, they could ask the sheriff to start. So kind of get this out of order here, but there's a 42-day period after a judgment becomes final for appeals to be filed. They may want to wait until the end of that appeal process to even ask the sheriff to do it. They don't have to wait that whole time, but they may want to. And so, but the answer to your question relates to that, which is Credit Suisse may not want the Trillium foreclosure to be scheduled and a 54B certificate issued, because there may be an appeal taken on the Trillium project. And I guess, I don't know who all might appeal, but certainly I'm aware that Scott Hedrick Construction asserted priority over Credit Suisse's mortgage in the Trillium portion of the project, and the court denied Hedrick's priority status on that portion of the project. And so it's possible that there could be an appeal there. And what they don't want to have happen is, like I was explaining before, a stay being issued because of an appeal being filed on another portion of the property. And so there's some risks to them to not get, if they're going to do a sale now, that they may want to have a final judgment just on their portion. That's what I think might be motivating that, but that's just a speculation.